Hello guys, and welcome to another episode of my lecture. Today we'll be talking about act and liability of officers and agents under section 91. Now do not forget that when I was speaking on act and liability of officers and agents, I spoke about section 89A and B. I want us to juxtapose these provisions in relation to act and liability. Let us start from 89A, the very place we're coming from. Now from section 89A, you would see that it says that any act of members in general meeting, the board of directors or the managing director, they were express in saying any act of the members in general meeting, of the board of directors or the managing director. This is to tell us that when we are talking at act and omission, that will be the act and omission of the company under section 89A and B. It is restricted to just those three: the board of directors, members in general meeting, and then the managing director. Officers and agents do not come under this section. Officers and agents will come under section 91, which is the next thing that we are talking about now. So under section 91, it tells us, except as provided in section 89 of this act, the act of any officer or agent of a company shall not be deemed to be the act of a company, except the company acting through its members in general meeting, the board of directors, or the managing director shall have expressly or impliedly authorized such officer or agent to act in that manner, or the company acting as mentioned in paragraph A shall have represented the officer or agent as having its authority to act in the manner, in which event the company shall be civilly liable to any person who has entered into the transaction in reliance of such representation, unless such person had actual knowledge that the officer or agent had no authority, or unless, having regard to the position with or relationship to the company, he ought to have known of such lack of authority. This invariably will tell us that there are two things to look at here. We have the express or implied authority, as can be seen in A, that's section 91A, and ostensible authority, which can be seen in B. Do you understand? So under A, the principal must be either of the three organs: the board of directors, the member in general meeting, or the managing director. Only those three organs can expressly or impliedly authorize such officer to act. Now when we are going to the ostensible authority, ostensible or apparent authority can be found in B, where it says that the company acting in line with A shall have represented the officer or agent as having authority to act. This implies an agency by representation or estoppel, known otherwise as ostensible or apparent authority. Now, I'm very sure that you'll be asking a very important question, but this is the section that we should have quoted earlier instead of section 89A and B. This section is what discusses more the case of Leonard carrying, the case of Meridian, because this section tells us that where there has been an implied or express authority given by either the board of directors, the managing director, or members in general meeting, or where there has been an ostensible authority as well, that is when the act and omission of the officers or agents will be deemed to be the act and omission of the company. Why didn't you quote this section earlier? The reason I didn't quote it is because I wanted to start from the three principal organs first and tell you that it is only in rare cases, very rare cases, will you see that there is a dispute as to the act of the managing director or the act of the board of directors, and say, oh, the board of directors was not acting for the company and all that. It is most times by officers and agents. By officers, what does the comma define officers to mean? The comma under section 86 tells us that officers would include director, like as we could see in Leonard's case, manager, as we could see in the Meridian's case, in the Lady Gwendolene's case. In the Lady Gwendolene's case, the officer there was a traffic manager. In the Meridian's case, the officer there was the investment manager. or secretary, as we can find in section 868 defining to us what an officer is. While agent, according to the CAMA, is defined not to include a legal practitioner acting as counsel for any person. In this case, we've clearly seen who an officer is, we've clearly seen who an agent is. An agent is anybody that is not a legal practitioner. That means a person that is acting for the company. If you've done law of agency, you would understand this. So a person acting for the company is the agent of the company, although that person must have been appointed expressly, impliedly, ostensibly, and all other types of appointing an agent. Do you understand? So when we are talking about liability for act of officers and agents, section 91 is the section, not section 89A and B. Section 89A and B is only instructive when we are talking about liability of the managing director, the board of directors, and the members in general meeting. So all the cases that has been quoted, from Leonard's case to Ehrlich and Lifa, all has to do with section 91, because none of them called into question the board of directors, the member general meeting, or the managing director's ability to act as the company. They all called into question whether a director or a manager could act for the company, and those are officers and agents under section 868 of the CAMA. So we are going to our last case on liability and acts of officers, and that is the case of Freemian and Lockyer versus Buckhurst Park Properties. I would want us to pay attention to this, which is going to be in my next class. It's very, very important that we all pay attention to it and know what exactly the court either was adding to what we've learned so far on act and liabilities, or subtracting, or whether or not they just maintained the rule. I'll see you in my next class.